All right, Mr. Blade, let me stop you. That court rule is about civil cases, like if you're not paying your credit card bill. All right, Ms. Caitlin Foley, your appearance for the township. Thank you. Good morning, Mr. Blades. You don't have to jump up. They train them in law school to jump up. All right, so before we get to all the jurors here, and I guess they're coming in, I don't know how many we've got, but I wanted to take care of some pre-trial stuff. So you brought a bunch of paperwork in 2 weeks ago or so? Okay. Most of that I couldn't figure out if you were asking for something, if you just submitted that for the court to have it. The one thing that looked like an ask was you filed a motion basically attacking the Monroe County conviction again. Would you agree?
Yes, I mean, I put that in there.
Okay. Well, we argued that out once, and I told you that whether or not Monroe messed up, I could not overturn what happened at the Monroe District Court. You'd either have to go back to the District Court or the Circuit Court in Monroe County. Remember that? We argued that motion once? All right. Is there anything else that you want to deal with out of those filings or anything else prior to getting the jury in? I can't hear you. Yeah, pull it in. Okay. So you filed a stack of documents a couple weeks ago. Okay. I want to know if there's any of that you want to deal with now, because we're not going to argue motions in front of the jury.
Okay.
Okay. All right. So none of that filing is something you wanted to deal with before the trial. Okay. So you're planning on submitting 240 some pages worth of evidence today? Okay. Understand that all of that's subject to an objection from her if it's not relevant. Okay. All right. And I'm going to tell you right now, all of that stuff from Monroe is not relevant.
Talking about the record.
I'm sorry? The record. The driver. Well, the driving, I'm assuming the people will plan on introducing your driving record. Okay. All right. Okay. So do you have any other pre-trial questions?
Just want to be able to submit the evidence to the jury. So,
Okay. Well, I don't know if you will or not, because as you submit something for evidence, we'll have a discussion about whether or not it's relevant, whether or not it's probative versus prejudicial, all those things through the court rules. Understood?
you know, where these very, excuse,
That's all right. Take your time.
validity of the judgment. Validity of the judgment.
But it doesn't, and I explained that to you when you filed that motion. The Secretary of State, hold on, let me talk. The date of this arrest, if she can prove, she being the prosecutor, if she can prove that on the day of this stop, your license was suspended from the Secretary of State, the fact that it was improperly suspended by Monroe County doesn't change the fact that the officer had paperwork that said you were suspended from Secretary of State. That's why I told you months ago, you have to attack that judgment in Monroe if you think it's inappropriate.
He was what?
But, and I told you, I can't,
Never to overturn, just to recognize the jurisdictional defense. We are,
but hold on. It doesn't matter if I recognize something. Sir, don't interrupt me. Don't interrupt me. It doesn't matter even if I agree with you that Monroe did something wrong, there's still a valid suspension from the Secretary of State. But you have to deal.
This case starts with something judges see all the time, but it rarely stays this calm for long. A defendant walks into court armed with hundreds of pages of paperwork, convinced he's found the legal argument that will change everything. The problem? Courtrooms don't run on how strongly you believe an argument. They run on whether that argument is legally relevant to the charge in front of the court. As this hearing unfolds, pay close attention to the judge's patience. You're about to watch a fascinating clash between legal procedure and a defendant who keeps trying to revisit a completely different case. The central issue sounds simple: driving while license suspended. But what turns this into courtroom drama is the defendant's insistence that the suspension itself traces back to mistakes made elsewhere. The judge repeatedly explains a crucial legal distinction: whether another court made an error is not the same question as whether this court has the authority to fix it. That distinction ends up driving almost every tense exchange you're about to see. And here's what makes this especially interesting. The defendant chose to represent himself. That means every misunderstanding, every procedural mistake, and every missed legal opportunity lands directly on his shoulders. Was he uncovering a genuine injustice, or was he focusing on the wrong battle entirely? Watch closely, because before this hearing is over, we'll see warnings from the bench, threats of contempt, a rejected continuance request, an unexpected plea deal, and a judge who ultimately shifts the conversation from guilt to accountability.
But you can't deal with that here. Well, whether or not you can make that argument to them is based on the discussion we have. You want to have that discussion now, we can have it.
Because I feel.
Well, no. You're not going to present anything to the jury until I tell you you can't. That's the way it works. So let's argue that right now. You want to present your theory of the Monroe case. Interrupt me one more time, sir. We're going to have a long day today. Interrupt me again, and I'm going to hold you in contempt.
This is one of the most important legal moments in the entire case. The judge isn't saying the defendant is necessarily wrong about Monroe County. What he's saying is that this courtroom isn't the place to relitigate that dispute. Jurisdiction matters. Courts have limits on what decisions they can review and what orders they can overturn. Many self-represented defendants struggle with this exact concept. They focus on what they believe is unfair, while the court focuses on what it's legally allowed to decide. Do you think the defendant is raising a legitimate concern that's being ignored? Or is he arguing an issue that belongs in a completely different courtroom?
You understand that? If you want to present to the jury what you claim was wrong in Monroe that led to an improper judgment that went to a Secretary of State suspension, if you want to argue that to the jury, we'll discuss whether or not that should be in front of the jury today, right now. Is that your argument? Okay. All right. Is there anything else you want to? I tried to put in my words what you're trying to do. Do you want to put it in your own words so I can give Madam Prosecutor a chance to respond? Okay. Madam Pros?
To the courtroom.
Okay, well, that's too vague. That's too vague. That's too vague. Once again, yes or no? You want to talk about what you think was wrong in Monroe to this jury today?
No, I want to talk about the record and how it got there to the jury today.
And how are you, and what is that going to be?
That's going to be the laws of the four rules. The four rules, that's all I plan to present, four rules, and the judgments that are based upon the four rules.
Doesn't that get you to a discussion about Monroe County?
It all starts with the record. It all depends on how the record got there. What was that because prosecutor and according to your state you just made is the record. What he saw when he pulled me over is what he went by when he arrested. Okay.
Well, I can guarantee that's going to be part of the case because this is a drove while license suspended charge.
Has to be authenticated as to why it is there.
I disagree with you, sir. I disagree with you, sir. What the prosecutor's going to have to present today is a certified record from Secretary of State that shows you were suspended. There's nothing that says we have to get into why you were suspended or how you were suspended.
What
court rule are you referring to?
That's 2.105.
What's that say?
Individual. Process may be served on a resident or non-resident individual by delivering a summons and a copy of the complaint to the defendant.
All right, Mr. Blade, let me stop you. That court rule is about civil cases, like if you're not paying your credit card bill. That's for civil cases, not for drove while license suspended charges. Not for criminal cases. It most certainly is. It's a 93-day misdemeanor. Drove while license suspended, revoked, or denied. That's the top charge on your file. It's a criminal case.
It can't be a criminal charge because,
Sir, trust me when I tell you, I can put you in jail on this charge. By definition, that means it's a criminal charge. So we're not talking about civil court rules. It's irrelevant. Because that court rule, 2.105 is regarding civil process, not criminal. I told you when you said you wanted to have a jury trial by yourself, you were in over your head.
The temperature in the courtroom just jumped. When a judge mentions contempt, that's a serious warning. Notice that the issue isn't disagreement. Judges hear disagreement every day. The issue is interruption. Courtrooms operate on procedure, and repeatedly speaking over the judge can quickly turn a legal argument into a conduct problem. What's remarkable here is how much effort the judge is making to translate the defendant's argument into clear legal language before allowing the prosecutor to respond. That's often a sign that the court wants to ensure the record is complete and fair before making a ruling.
We're not talking about 2.105 today. Not in front of the jury.
I would like to move forward from the page.
I'm sorry, what? I don't understand what a containment is. Continuance? Absolutely denied. The jury's coming in today for a jury trial. We gave you a scheduling order that gave you plenty of time to file any pretrial motions. I gave you grace today when I talked about what you've brought in 2 weeks ago, because that was a day late. So absolutely no, you are not getting a continuance today. If you want to take 2 or 3 minutes and talk to the prosecutor about seeing if there's any offer, that's fine. Otherwise, we're going to a jury trial.
This exchange highlights one of the biggest risks of self-representation. The defendant keeps citing a rule related to civil procedure, while the judge repeatedly explains that this is a criminal matter. Those distinctions might sound technical, but they can completely determine whether an argument succeeds or fails. The judge's comment about being over your head may sound harsh, but it's also a reminder that legal systems are filled with procedural rules that aren't always intuitive. If you were facing criminal charges, would you represent yourself, or would you insist on having an attorney by your side?
Without an attorney, because that was your choice, with all 3 charges.
We're deciding the prosecutor, please.
I'm sorry, was that a yes to discussion?
Yes.
Okay, all right, take a few minutes, not a lot, because as soon as I've got enough jurors, I want to get them started if we're going to work them.
I'm almost positive we had that same 2.105 discussion last time.
I don't know because he's
Caitlin-
understanding now, because he didn't,
Caitlin will remember, but I'm almost positive we had that same conversation.
you were told him it was a civil matter and he would have had the same discussion about it not being a criminal.
Unless he didn't hear me then. I'm almost positive we did.
Mm-hmm.
At least he's fairly polite.
Yeah. And he's not angry and just, yeah.
Ms. Caitlin Foley, did you have conversation?
Yeah, we need to go to resolution for your child.
Okay, what is it?
Total license suspended, we will be dismissing the operating correction vehicle as well as the unlawful use of license plate.
Okay. Mr. Blades, correct? You understand your rights and the options those rights present? You understand the possible penalty of the charge is up to 93 days in jail, up to $500 fines plus court costs? And that's the deal you want to make today? Did you drive a vehicle in Huron Township on November 29, 25? At the time, was your license showing as suspended, revoked, or denied from Secretary of State's records? Are you satisfied with the plea? I'll accept the plea to count 1, dismiss counts 2 and 3.
And just like that, the strategy changes. After spending much of the hearing fighting over legal theories, the conversation shifts toward negotiation. This happens more often than people realize. Sometimes, a defendant enters court, prepared for trial, only to discover that the risks of proceeding outweigh the potential rewards. What's interesting is the timing. The jury is on the way, the continuance request has been denied, and the court has made its position on the legal arguments crystal clear. Suddenly, settlement discussions become a lot more attractive.
Mr. Blade, let's talk about your financial situation. Are you working? Yes? Where do you work? Full-time job? Full-time job? And, all right, anything else you want me to consider before I sentence you? Yeah, lean up, yeah.
What do you find? Don't say no to my brother.
Tell me about it. In a word? Go ahead. Okay.
I'm scared. I have bills, I have friends, I have children, but I don't have a lot of playtime. I have to get back and forth to work. So that really has us. Really.
Give me, all right, give me an idea. What kind of shift are you on? What kind of schedule? 2 p.m. to 10 p.m.? How many hours a week you're working? Okay, well, what's a minimum in a week? I mean, like 35, 40 every week, or it could be 0 to 40?
I get regular work daily, just how many hours I'm working.
Okay. All right. So let me ask you this. Or let me tell you this. We've got other files in this building. One of them goes back to 10 years old, 2016. Currently, you owe us over $3,000. I don't see any attempts to make any payments on these.
On nothing. You did that.
Okay. All right. So,
Be a good thing. First time you
yeah, well, I'm not gonna pay a clerk to process a dollar payment. I mean, that's a net loss to the building. So I've got some options. Well, first of all, let's talk about the old money before we talk about today's file. On the $3,000, yeah, you guys don't have to stick around for this if you don't want to. For the $3,000, I can send you down and we can put you on the work program. Unfortunately, that means you got to be out here because we don't do the work program in Monroe. I can give you work days, which means you pick the days. The days you pick, you have to be here at 8 o'clock in the morning to go out with the crew. Or I can give you some community service hours, which means you work with a charity, nonprofit registered with the IRS. You can work off our list, or you can find someplace closer to Monroe County or, closer to home. But it's got to be an IRS registered nonprofit organization. You have to do X number of hours, document it on their official letterhead so we can confirm it with them and document that or present that to the court.
This is where the case moves from determining responsibility to determining consequences. The plea has been accepted, and now the judge is evaluating the defendant's financial situation, employment status, and ability to comply with future court orders. Many viewers focus on the dramatic courtroom arguments, but sentencing often has the biggest impact on a person's daily life. The court wants to know not just what happened, but what outcome is realistic and enforceable. Notice how detailed these questions are. They're helping shape what comes next.
So those are options how we can pay off that $3,000. All right. So I'm going to send you downstairs on the $3,000. I'm going to send you downstairs to talk options. All right. So on today's file, normally I sentence $500 on this. So I'll do, let's see, 4 days. What is today? Early. July 10th. All right. So on today's file, it's $500 or 4 days on the work program or 30 hours community service. One of those three has to be done between now and July 10th on today's file. You understand that? You want to do work program? Set that up downstairs. All right. And as far as the $3,000, they'll talk about your options down there, whether or not you want to do work days, charity hours, some combination, they'll work something out. Understand that work program days are assessed as an alternative to jail. That means if we give you a schedule, we expect you to be here, because if we give you that seat, we can't give it to somebody else. All right. So if we give you a schedule and you don't show up for one of those days, we'll give you, we'll give you a reschedule once. After that, you're probably doing the jail days. I can't hear you. The work program isn't, I just said that. Work program is done here. You have to, if you pick work program, you got to be here at 8 o'clock in the morning. I can't do it in Monroe County. My work program runs my 5 communities. I don't send a crew to Monroe County. The charity hours you can do in Monroe, but those aren't 4 days, those are hours. Charity is hours, work program is days, just like jail is days. So if you want to do the charity, go downstairs and talk about that.
the chair, that's what.
So on today's file, that means 30 hours between now and July 10th, documented by July 10th. Clear? Okay, go on downstairs.
The judge is now laying out multiple pathways for resolving not only today's case, but also years of outstanding financial obligations. This is a practical side of the justice system that rarely gets attention. Instead of immediately imposing the harshest consequence available, the court is presenting alternatives, work programs, community service, or monetary payments. But there's also a warning embedded here. Flexibility comes with responsibility. Once a defendant agrees to a program, failing to follow through can quickly eliminate those alternatives and expose them to more severe penalties. Accountability doesn't end when the hearing ends. What began as a dispute over paperwork, court rules, and an old suspension ultimately ended in a plea agreement and a practical sentencing discussion. Throughout the hearing, the judge repeatedly emphasized a key legal principle. A courtroom can only decide matters within its authority. No matter how strongly the defendant felt about events in Monroe County, this court's focus remained on whether his license was suspended at the time of the traffic stop. The case also serves as a powerful lesson about self-representation. The defendant came prepared with documents and arguments, but preparation alone doesn't replace legal expertise. Understanding which laws apply and which court has authority over a dispute can make all the difference. In the end, the judge accepted the plea, dismissed additional counts, and offered several options for addressing both the current sentence and outstanding financial obligations. The ruling balanced accountability with opportunities for compliance, while making it clear that future failures could carry serious consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.